A very good evening to all law students and professionals who have joined with us in this webinar presented on preventing juvenile delinquency in children by Honorable Speaker Mr. Veer Vikrant Singh, who is a Deputy Advocate General State of MP at Supreme Court of India, who is passed out in 2014 NLU. Now I would like to invite Sir to enlighten upon the present topic. Start.
Hello, good evening. I am here to address you all today on the topic of how to prevent juvenile delinquency in India. First of all, I would like to thank Trendsetters for providing me this opportunity to speak on this forum, and I think I would be able to satisfy your inquisition and your questions through this medium. So, what actually is juvenile? We have heard the word juvenile in our daily life. We have been reading it in newspapers for issues pertaining to juvenile trials, juvenile crimes, juvenile justice. A number of material is available on the internet, on books. A number of books are. But so far as the concept is concerned, it needs to be understood thoroughly in its concepts for its proper implementation. Since in India, we have been having the concept of juvenile delinquency before independence, and nowadays it is more as the number of crime rate is increasing, and with the rise of crimes committed by juveniles, there is concern emerging in the society as to how to prevent it, what efforts needs to be made to prevent juvenile and to stop juvenile offenders from committing such crimes. Also, we are searching for mechanisms in the society to rehabilitate these juveniles so that they can lead a better life and we can be a good citizens in the future. So today in our discussion, we will discuss actually the concept of juvenile, the nature of the concept, how does it emerge, how has it dealt by the international fraternity, by the United Nations, and how it has impacted the Indian legal system. So primarily, we will understand the concept of juvenile first. Juvenile, juvenile is a word which has been termed for a child at a certain age who is not able to commit the crimes of criminal in nature like adults. Also, by the meaning contained in Juvenile Justice Act, juvenile word has been defined for a child who is below the age of 18 years. The word delinquency has been derived from the word delinquer, which means away, and linquer specially means to leave. Initially, it was used for the people who used to leave their childs, who used to neglect their childs and their children, and who used to commit socially unaccepted acts. In US, it has been the authority conferred to every jurisdiction of the state that they can decide the age of the juveniles according to their authority within the territory who reside. Now, juvenile delinquents were considered to be children whose behavior was his behavior was, you can say, was not in consonance with what was socially prescribed for the children. It was considered as a disorder, which a child when a child tries to works or acts like a grown-up adult. But W.H. Seldom, in defining judicial delinquent, has considered juvenile delinquents as a disproportionate behavior beyond reasonable expectation. Frederick Simpson has described the nature on the basis of the acts on which he defined delinquents like violation a child below the prescribed age who violates any law, habitual of committing any offense, who has been associated with thieves, committing committing acts which were beyond the control of parents, which were immoral. Now, when you talk about the terms of juvenile delinquency, it was first dealt in 1889 when the state of Illinois described the word and framed a law, juvenile law, for its country. It was considered to be an act performed by a child, which is prohibited in a statute. Lord Gibbons, in defining juvenile delinquency, said that a juvenile delinquent act consists of acts which are prohibited in statutes framed by law. Now, India has, through its legal journey, has adopted various suggestions, various characters, various conventions, which were laid out and the recommendations which were included in the United Nations Congress. For example, in the Children Act of 1960, children who have been found to have committed an offence were considered as juveniles. The Juvenile Justice Act of 1986 defined children below the age, a male on the age of 16 and a female at the age of 18 to be juveniles. Juvenile Justice Act 2000, when it was revised, when it was amended, it provided a flat age of 18 years for considering a person to be juvenile in consideration of the United Nations Declaration. Now, before going deep into the concept, let me apprise you of some of the facts which have been decided, which are according on the basis of National Crime Records Bureau, and which deals with the offences committed by the juveniles in the country. So, in the data available of 2018, the total number of juvenile delinquents were 31,591, and the crime rate was 7.1% of the total crimes in India. Maharashtra topped the lists with around 5,880 cases, which amounts to about 15.5% of the total crimes committed by juveniles. The maximum incidents in which the juveniles were involved includes theft, followed by minor hurt or grievous hurt. The numbers were 1606 and 5102, respectively. Specifically dealing with the age group of 12 to 16, the number of theft offences were 2,623, whereas the offences of hurt was 1,572. The maximum number of offences were committed against women, which were numbered around 1,318. At present in India, the total number of cases pending or disposed against juveniles is 76,585, in which 87% out of which 87% of the cases the juveniles were held to be guilty, and 41,709 offences were constituted of petty offences. Now, if you see in metro cities where a large number of juvenile offences are raising, Delhi tops the list among all the metros, which with offences of 2,388 are committed by the juvenile offenders. Now, if you see, this juvenile delinquency has been characterized, or it has been classified on two grounds. First is neurocratic, based on the influential unconscious impulse which imbibed the sense of guilt in the child and which made him commit offences. The second one is the character descent, the descent which belongs to family, under which a family neglects its child and provides him inhospitable environment, because of which a child turns out to be a juvenile offender. The common offences committed by a child includes theft, assault, alcohol, truancy, vandalism, possession of illegal drugs, sexual offences, etc. Now, if you see the possible reasons which are the cause of juvenile delinquency is poverty. Arising out of poverty, many children are forced to commit such act, by which they tend to gain money for satisfaction of their illegitimate needs, for which they commit all such kind of petty offences, including theft, including hurt, etc. Also, family plays a major role in providing juvenile delinquency. The in our modern times, we find that people are so much engaged in their professional life that they have hardly any time for their children. The children are brought up in ignorance and lack of proper care, turns out to be juvenile offenders in their later age and contribute in the offences of committed by juvenile offenders. Also, the neighborhood plays an important role as to how a child is upbringed by their parents and in what society is he living. The society causes a deep impact upon the character and the morals of the child. And if the society is not good, or if there are such acts committed in his neighborhood, he will certainly be guided and encouraged to perform such acts in his daily life. The mental health. There are certain mental taboos which exist in children where they feel themselves inferior, and in order to prove themselves superior, they sometimes turn out to be juvenile offenders or commit such acts to gain attention of the people around them. Such acts may result in and turn them to be a juvenile offender. Virtual world these days, you see most of the people are so much they are influenced by social media, by social networking sites, by movies, by ad films, by cartoons, by serials, by series. So certainly the material available on the internet, the material on social sites, it certainly plays an important role in molding the child's character and his nature. And it also encourages few children out of attraction to commit such heinous and grievous crimes, which lays them into crimes of juvenile offenders. Also, if a child is under a bad company, or his friend circle is not good, or he is in company of such people who encourages him or motivates him, or allows him to do such acts, and also does not restrain him from committing such acts which are immoral, that person may gradually, after some time, may land up into offenses of juvenile offenders. Now, this concept, as you see, it has been emerged from the United Nations Congress, and with the establishment of United Nations, it has been brought into light of the United Nations Congress that it has become contrary to the objectives set out by the United Nations for the growth and development of the children around the world. The United Nations, in its attempt to mold or to improvise the situation, has laid down certain guidelines during various conventions, under which it provides the required guidelines or the directions which need to be complied by the United Nations supporting citizens United Nations supporting countries, who have to deal with the issue on an organized manner, and to see that it does not hampers the growth of the child and its overall development. So there are various international instruments and conventions with regard to juvenile justice, which I will apprise you about. First is the United Nations Standard Minimum Rules for Administration of Juvenile Justice. It is popularly known as the Beijing Rules. The Beijing Rules provide guidelines on how children should be treated in criminal justice society. It lays down certain guidelines or certain points on which the laws of the country have to be made, and it needs to be ensured by the signing countries that the children are nowhere exploited in the name of crime prevention, and they are not being treated as other criminals, and also that their reformative or the rehabilitation process is being carried out by these countries in consonance with the legal system. The United Nations Guidelines on the Prevention of Juvenile Delinquency, also known as the RIAD guidelines, provides the methods for discouraging juvenile delinquency. It lays down the condition as to which could be adopted by the countries to discourage juvenile delinquency in the particular areas. It provides mechanism for children's growth, development, for its mental care, for counseling, so that it could be adopted while handling juvenile offenders. The United Nations rules for protection of juvenile deprived of liberty, known as the Havana Conventions, deals with the counter effect of the detrimental effects of all types of detention. It basically deals with that the juveniles should be kept in separate prisons, and they should not get impact with the habitual offenders hanging out in jails. Because, as I said, the company certainly have a deep impact on the moral character and mental state of the children. So it was prescribed in these guidelines that the children should be separately dealt and not as the habitual offenders in the jails. The guidelines for action on children in criminal juvenile system, known as the Vienna Convention, it provides various measures which needs to be adopted by the countries towards juvenile laws, establishing juvenile care authorities, juvenile protection laws, juvenile, juvenile suggesting juvenile action committees, which are going to monitor the stage of the juveniles, which are going to monitor the condition of the juveniles after being rehabilitated. so that they do not further get it indulged into any immoral or illegal activities. Now the juvenile justice system in India has been deeply impacted by the existing laws of that time. Even pre-independence, the Apprentice Act 1850 deals with petty offences pertaining to child between the age of 16 to 18, and it provides reformatory measures that such children should not be deemed as habitual offenders or regular criminals. The Criminal Procedure Code 1973 provides provisions which deals with juvenile offenders. For example, Section 399, which says child below the age of 15 years should be sent to reformatory school, not to prisons. Now, this certainly is a major development in juvenile laws in India, where in the recent Nirbhaya case, there were questions regarding to the age of the main accused, who just escaped for the reason that his age was 18 years. So, such challenges emerged, the Indian law have further catered to this clause in its amendments, but in the CRPC, it still exists that a child below the age of 15 earlier and now at the age of 18 should be sent to reformatory school, subject to the discretion of the juvenile boards. Also, if it was laid down that a juvenile offender could be discharged on probation rather than keeping him in jail, so that his mental state is not affected by the company of the other offenders who are languishing out in jail. Section 82 of the Indian Penal Code 1860 specifically deals that a child below the age of 7 years is not to be held for criminal offences. Also, Section 83 relaxes this age in certain offences up to the limit of 82 years. Now, the Juvenile Justice Act 1986 was specifically made in the light of United Nations conventions, as discussed above, and it was framed in the light of United Nations Charter. The major emphasis of the major star points of the Juvenile Justice Act 1986 was that it provides special approach towards the control of juvenile delinquency in India. It came up with a machinery to enforce and provide infrastructure for juvenile delinquents in the country. And also it laid down established norms and standards for administering the Juvenile Justice Protection Act. Now, the Juvenile Justice Care and Protection of Children Act 2000, it stresses on protection of children more rather than providing them punishment for its offences. The age was made uniform of 18 years. There was a separation between the children of the age of 8, the children who were in need of care, and then who were the children who were in need of conflict. This was a major change which the Act of 2000 incorporated in its amendment. It also provides for constitution of child welfare committees and juvenile justice boards at various levels to deal with offences and welfare of these juveniles during trial and when they were sent to rehabilitation in juvenile homes. It ultimately expanded the scope of the law for as it tried to include many such offences which were earlier not part of the Juvenile Justice Act 1986, and it affords more legal protection to juvenile offenders as compared to earlier laws. The Juvenile Justice Care and Protection of Child Act 2006 further structurized the juvenile justice system in India. It provides special approach to the protection of juveniles and established norms and standards for administration of juvenile justice in the country. It constitutes special offences under which juveniles could be tried, and also coordinated between the formal system and the voluntarily acts committed by the juvenile home by the people towards reformation and rehabilitation of the juveniles. For example, earlier there were vast difference between the work committed by the prison by the government authorities and by private organizations, NGOs, and it was found in the report that these NGOs were far better involved and they have a far better reach as compared to government. regarding juvenile protection and juvenile care. So in order to coordinate better, it was provided in the law that such organizations can work and in consonance with the government organizations, and also they could provide the regular feedback to the government, which can certainly help the government in structurizing and reforming the juvenile justice system. And also the NGOs could be held by the government in a better manner so that they could maximize their input and provide maximum feedback to the government pertaining to juvenile justice system in India. Later, when the Juvenile Justice Act of 2015 was passed, it has been affected by a number of legislations. It was a number of acts which have arisen during the course of the time. The famous Nirvaya case have arisen, and there was a debate going on in the country as to what could be the age of a juvenile and how could it be determined that a juvenile could be tried by a regular law, or he could be it could be put under trial under the Juvenile Justice Act. So there was the Juvenile Justice Act 2015 caters to all these needs provided, and it laid down that it gives the juvenile justice homes boards the power to decide whether a juvenile is to be tried under as a juvenile or an adult or not. Certainly, as we have recently seen, and there was a criticism of this law that juvenile homes have not be that juvenile law is not able to accommodate and not able to cater the rising crime rate in India. So it was an attempt made by the government under Juvenile Justice Act 2015 to provide conferring powers to the juvenile justice boards so that they can determine on the facts and circumstances of the case that a person needs to be tried whether as a juvenile or as a regular or as an adult. Secondly, it streamlined adoption of special children, children of or children who were often abandoned or handicapped. Earlier, there was no specific mechanism to deal to determine the adoption of such children, and such children were generally neglected during adoption process by parents, and they were earlier considered as a burden. Also, due to their complex health conditions, there was a mental framework of ignorance in the society that such children could not be ignored. So, with the Juvenile Justice Act 2015, it streamlined their adoption and provide various guidelines as to how such children could be adopted. It introduced foster care programs, which includes where the adopting families will be monitored by the juvenile committees and by the district administration, which was earlier not possible and for which no mechanism was earlier laid out, because of which it was it was held that such children after adoption were either sold, were trafficked, or were suffered from harassment by their parent families. This law laid down that priority should be given to children of disabled category while adopting. So another, it was a welcome measure by the then government who laid down that such children should be prioritized in adoption and they could find a suitable home for themselves who could take care of their needs and their growth. Also, it prevented the 3 months, it provided the parent an opportunity to think about whether they have made a decision to adopt right or wrong and provided a period of 3 months to reconsider their decision of adoption. In case they find it inconvenient to carry out the upbringing of the child, they can inform to the district administration and the administration would certainly take care of the needs of the children. Recently, the Juvenile Justice Act 2018 empowers the district magistrate to issue orders for adoption, which was earlier not provided in the earlier acts. Also, it laid down that the district magistrate that all the cases of adoption lying in the district would now be transferred to the district magistrate, who will deal with the specific cases of adoption. such children would be treated. Now, apart of so many reforms and so many measures taken by the Indian as well as the international community towards juvenile delinquency and towards juvenile delinquents, there are certain challenges and issues emerging in our country pertaining to Juvenile Justice Act and juvenile delinquents. The Juvenile Justice Act provides that the juveniles needs to be rehabilitated within a particular framework, but it has been seen that this period is either too long or too short for a juvenile to be dealt with. The a law requires flexibility whether such period should be 3 years or not. Also, despite of various provisions of juvenile laws, establishment of various authorities, it has been found that the administrative machinery is not able to implement effectively the provisions of the Juvenile Justice Act. The children who are adopted are harassed, they are being sold, they are being assaulted in the families, and there is no one to properly monitor these children. There is also lack of mechanism to track the children once they are being left from the prisons. And ultimately, it is being found that in the recent year, the such children, despite of being kept and brought up in rehabilitative homes, are turning into be juvenile regular offenders. So that poses a very deep challenge before the administrative authorities as to how to track those children among such complex administrative structure and machinery. Also, it was found that the Juvenile Justice Act was also not considered appropriate in certain areas. It was very difficult to implement the idea of juvenile justice in places where children were not kept in regular jails, but they were not kept in juvenile jails, but kept in adult jails also. There are the gross number of children who are still languishing in jails, who are yet to be determined as juveniles, who are yet to be reformed are yet to be reformed, who are yet to be treated by the juvenile justice boards. So there is a challenges of accountability before the administration as to how to cater to the situation and how to mark and point out such children and to determine their juvenile rights within the existing administrative machinery. Also, there is lack in the juvenile homes established by the country by the law. There is lack of proper training of its employees. The employees are generally educated but not trained in a manner to deal with such criminals, which creates a gap or a loop or a gap or a void between the children and the administration or the officials working in juvenile homes, which is which derails the entire process of reformation of the children. There is also instances of corruption being found out in the juvenile homes by the officials. Also, there is lack of counseling in such juvenile homes where the officials are merely working as employees and not as counselors, and they are failing to establish any sort of bond or any sort of communication between the juvenile offenders and the children. The juveniles are also the juvenile boards are or the juvenile committees or the juveniles are also not subjected to assessment. They are not regularly monitored because of which also there is no proper monitoring of these authorities, ultimately diminishing the purpose for which these juvenile homes were created. The government has constituted the Justice Verma Committee, which in its report have laid down certain suggestions towards adoption by juvenile homes and needs to be incorporated in the law pertaining to juvenile justice. It initially suggested that the court should be more towards adopting reformative approach rather than punishing the juveniles. The focuses of the court should be more on the reformation of the children who are being tried by the courts rather than on punishing them. Also, it emphasized that more power should be given to international conventions and provisions of CRPCs rather than state laws for better enforcement, so that there is a twofold mechanism to monitor the implementation of the laws. And also, there is a system of check and balance which could be created so that the system efficiently works. Also, it provides that for the officials or the workers working in the child cycle or the juvenile homes needs to be trained specifically in a program of child psychology, so that the members of juvenile justice boards are able to understand the temperament of the children and to decide in their context as to what is beneficial for them. Now, coming at the concluding part, what measures needs to be adopted for stopping this juvenile acts of juvenile delinquency? Initially, as a being a law reform, we needs to establish certain child guidance clinics in every place where children could be taken or children can reach out and they can share their mental and psychological conditions, and they could be guided according to the nature and compatibility. Also, the family needs to be educated, and they should be made to realize the importance of gaining or giving proper attention to their children, so that their children are not misguided and are not exploited or does not turn out to be a juvenile delinquent in future. Also, the children who are underprivileged, they needs to be given proper assistance so that they do not get into the guilt of inferiority complex and turn out to be criminals in their later age. Also, the social environment around the societies, the towns, the areas around, they needs to be they needs to be improved. The children should get an environment to grow up in a manner so that they become a law-abiding citizens, and also they become aware of the consequences of their acts. Also, the general economic conditions needs to be improved to provide children to prevent children from becoming delinquent, and they could easily understand the consequences of the act, and they should be able to gain out of the various reform mechanisms carried out by the government towards the juvenile laws by means of juvenile laws, and also they could understand what effectively needs to be done towards becoming a future good citizen of this country. So I guess that is what juvenile delinquency is all about. It specifically is a concept which is more nowadays, because we see there are major loopholes existing in the society when we deal with crimes, and with the rising number of crime rates, this has been a question every day as to how juvenile delinquency will be. We have the existing mechanism in our laws which have been provided consequently and made flexible by the government to adopt such mechanisms which could be carried out. But it is our duty to understand these reforms, these laws, and to provide such environment to the children so that they abstain from becoming juvenile delinquents and become a good future citizen of this country. I open the house for questions if there are any. So the financial MC juvenile system includes sanctions after youth goes to court. The juvenile justice system includes a juvenile justice board, the child welfare committees, as well as the courts in providing assistance to such juveniles. So far as the sanctions are concerned, the sanctions are provided. The sanctions are now being laid down by the juvenile justice board as to how such criminals are to be dealt with. what measures have to be adopted, and to determine whether they should be treated as regular criminals or offenders. Next is Vinny. Sahil says there are several instances of juveniles turning into repeated offenders, which points to the failure of the existence to rehabilitate and reconcile and conflict of laws. Yes, certainly. For the reason that is why I discussed that earlier, there was no differentiation between the juvenile offenders and the regular offenders. They were kept in cells with the same offenders as regular offenders. So what was found in the study is that it caused a great impact on their social as well as moral behavior. And even after being kept in jail for a period, for a certain period, they were turning out to be regular criminals. So when this was considered by the government, it was found out that such juvenile offenders needs to be separated from the regular offenders, and also were set up, mechanisms were established and provided in the law, so that such offenders could be separately dealt by the law and not as the regular offenders. Is it?
Now we can end up session.
Okay, thank you all for joining me, and I congratulate the team once again for organizing this lecture. Thank you
Thank you
so
so much,
much.
sir.